All right, to talk more on that in studio this morning, we're taking Njao, is joined by Counsel Stephen Mogaka. Any questions you might be having, 22422 is the SMS line, or you can get us on Twitter. The hashtag is Power Breakfast.
Welcome, Mr. Mogaka. This is your first time here. I think I've not seen you before.
Thank you so much. Nashukuru.
Now, this decision by the Kenyan government that we will not take the 3 suspects, in your view, is it going to be successful, or is it, anyway, it cannot be forced? What is the significance of this?
No, the significance of this is that the country, which is a sovereign state and member state of the Rome Statute, is seeking to reclaim its sovereignty belatedly, because you will recall that under the Rome Statute, every state party is required to take steps on its own motion within its jurisdiction to bring to book any person suspected to have conducted themselves in a manner that is violative of the law. What we are faced with now is a situation where there are warrants of arrest requiring 3 Kenyans to be surrendered to the ICC. Kenya has 2 choices. 1, to comply with the local law on extradition, or 2, attempt what the Attorney General is trying now, saying, well, under the principle of complementarity, every state party is entitled to exhaust its internal mechanism before ICC kicks in. The question then now that the country is going to face is this an original case or as an offshoot of an existing case? Criminal law and legal practice all over is such that if there is a court that has a position that a party has misconducted themselves, it is that court that conducts the trial.
In this case, is the ICC.
It is the ICC that is seized with the jurisdiction, and it is the ICC that is really complaining that there has been obstruction and interference with witnesses of that court. Will then Kenya be really entitled to purport to seek to conduct a trial on a case that stems from an existing case in the ICC? That is the question legal minds are going to be embroiled in. But in my view, Kenya is on its right course. It is making an application to the ICC that in lieu of extradition, can we be given an opportunity to conduct this case? It is up to the prosecution, which is also rightly entitled, to insist that these crimes arise out of a criminal proceeding of the ICC, and therefore Kenya has no business purporting to want to conduct its own trials, no matter how effective and reforms the Kenyan system has gone through. So this is the question that the country is going to get through. Whether the prosecutor now decides that Kenya is not cooperating and proceeds to the state parties, to the assembly of state parties, is a question to see. Similarly, whether Kenya decides that the prosecution is not cooperating and giving Kenya the right to exercise its duty as a state party, Kenya then also has a right to mount its complaint at the assembly of state parties.
In fact, the Attorney General said so.
Oh yes, those are options available, and it is really going to be a showdown between the ICC and the Republic of Kenya as to who should be the one conducting the trial of these 3.
Let's look at the case about Barasa, which is what is the status of that case? Because the other people identified by the ICC late, but Barasa's case has been pending. Yes, what's the status of Barasa's case? It
has been pending because the proceedings at the High Court have not been concluded. Remember, every person has a right to have their day in court. Barasa has gone in court challenging the extradition proceedings, and that process has not been exhausted. Unless and until it is, and a decision is taken by the High Court on whether Baraza should be extradited or not, that case is still alive before the High Court. But it will be interesting to see what happens now that the AG is of the view that he'd rather open criminal proceedings in Kenya. Whether that will prejudice the existing extradition proceedings against Baraza or not, I do not know. That time will tell.
What about the other two?
The other two are persons who have been named after the conclusion of the ICC case against the Deputy President and journalist Sang. These are recent warrants that have been issued. Extradition proceedings have not even commenced. So for those ones, it will be interesting if the Attorney General proceeds and commences criminal proceedings. Then we will see. It will be a standoff. It will really be an impasse, because if, and indeed as the AG says, these are offences that can be prosecuted locally. If they mounted the prosecution against these two, then they will rightly tell the prosecutor those cases are ongoing in Kenya, and the best thing is to forward any more evidence you have so that it is done in Kenya. And then whether the prosecutor will then say, no, Kenya, you have no business in this case. It is my case. These are scenarios that we expect to play out in due course.
But Kenya are not of its own. Kenya of its own has not found any other suspect having interfered with the witnesses. Because there are claims people are killed, people are bribed, people are whatever. There are so many allegations against witnesses, interference of witnesses in Kenya. Kenya has never of its own found anybody culpable.
Yes, but these are complaints coming from ICC.
Why would the ICC want to trust Kenya will do it, and they have not initiated their own cases? Kenya has not arrested or suspected anybody having interfered with witnesses.
No, an allegation of interference with witnesses is an allegation by the prosecutor. It is not an allegation by Kenya.
Yeah.
If and when the allegation by the prosecutor is investigated, and this is really what Kenya is saying, if it be true that there have been interferences, that is what the Attorney General is saying, let us have the evidence and we mount a local prosecution. On the other side, the prosecutor is saying, we have evidence, and I think a skeleton of such evidence has been given to the Republic of Kenya that justifies a mounting of criminal proceedings against the additional two perceived interferers with the witnesses. So it is true that Kenya will be seen to be pretentious when they are saying, let us conduct the prosecution, when they ought as a state party to have also conducted their own investigations to establish whether or not witnesses have been interfered with. In any event, this interference was within the Kenyan territory, and as a state party, it was duty-bound to ensure total cooperation with the ICC, including ensuring that there is no interference with the witnesses. This is what weakens the Kenyan belated application that they want to conduct the proceedings, the criminal proceedings against these three people. And whether or not Kenya will get their way, or whether or not the prosecutor will get her way, that time will tell as we see the play of by either party.
Is this the Attorney General's utterances come after the President's statement during the prayers in Nakuru that we will not send any other Kenyan there? Is this now a political matter, or is it a legal matter?
It is both a political matter and a legal matter. Well, the President has sworn to defend the Constitution of this Republic and to ensure that every citizen of this country is protected. So, true to his oath of office, he was within his right to say that no person should ever be tried outside Kenya. Remember, the trials the the 6 were undergoing through in the ICC was because of a fundamental constitutional error by our parliament, which had the liberty to establish a local tribunal to conduct the trials of matters arising out of the post-election violence. But in their wisdom or lack of it, they opted for Hague. So really, it is Kenya's choice to have gone to the Hague. And the president himself having gone through, I think it was wise and patriotic of him to really say that no Kenyan should ever be subjected to that kind of process, because I mean, it's an exhibition of a failed state which does not have a legal system to deal with its own issues. So for the state, the head of state to make that statement is really a restatement of what his oath of office requires of him, to ensure that in Kenya we have a mechanism that ensures that justice is done and seen to be done. And for the Attorney General, who is the principal advisor to the President and the Republic, I think he is also within his mandate to say, well, Parliament may have taken us to the Hague, but this time round, let us ensure all Kenyans get their justice done locally, because we are able.
So in this clash, who is the final arbiter? The state parties? In
this clash, ultimately, if no party concedes, then we see both Kenya and the ICC getting to the state party, to the Assembly of State Parties, to get a final position. But I see the ICC conceding. I see the Kenya conducting its own trials, and I see at the end of the day the evidence being brought down to Kenya for the trial to be commenced locally.
And suppose the trial is brought here and no prosecution take place, what can the ICC do?
We will cross the bridge when we get there. Let's not be too skeptical.
Thank you very much, Mr. Mogaka. I think now we are clear about what the situation is all about. Thank you very much. Let's now go to continue with the news.
All right, thank you very much, Mr. Njao.